Good evening, Western Standard viewers, and welcome to Hannaford, a weekly politics show. I'm Jen Hodgson, filling in for Nigel Hannaford this week. It's Thursday, February 6th, 2025, and my guest today is Christine Van Geyn, Litigation Director at the Canadian Constitution Foundation. Today, we're going to be talking about the federal government's appeal to the January 2024 ruling that the invocation of the Emergencies Act on peaceful protesters on Parliament Hill during the Freedom Convoy in 2022 was unlawful. But first, a word from our sponsors. This episode of The Hannaford Show is sponsored by New World Precious Metals, based right here in Alberta. Years of inflationary money printing and rising debt have decimated the average Canadian savings. Gold and silver are the only currencies that have held their value for thousands of years, and last year saw 30% gains. NWPM offers unique platforms to help protect and grow your hard-earned wealth with gold and silver. Check out newworldpm.com. Christine Van Geyn is the litigation director at the Canadian Constitution Foundation. She was in the Toronto Appeals Court this week for a two-day hearing on the Emergencies Act appeal. Justice Mosley in 2024, January, ruled Prime Minister Justin Trudeau's invocation of the Emergencies Act, which included a crackdown on Freedom Convoy protesters and the freezing of bank accounts for participants and even donors, was illegal. Within minutes, the Liberals filed an appeal. Christine is here today to discuss that appeal and what transpired in court this week. Christine, welcome to the show.
Thanks for having me on.
Oh, happy to have you. Can you fill in our viewers who may not be familiar with the Emergencies Act appeal?
Yeah, so just for background, this was a legal challenge to the Trudeau government's use of the Emergencies Act, which was invoked in response to the 2022 Freedom Convoy. That was a protest that was pretty noisy. Protesters were upset about a vaccine mandate for cross-border truckers, and then more broadly about pandemic era restrictions that had gone on for quite a long time. They went to Ottawa, and a lot of people agreed with the perspective of the people who were engaged in the protest. If they didn't agree with the means deployed, a lot of people did understand why these protesters were upset. Some of the means they engaged, though, included blockading roads and blockading 6 border crossings. So these protests went on for quite a while. Trudeau decided in response to this to invoke the Emergencies Act on February 14th, 2022. They issued a proclamation that what was called a public order emergency existed under the Emergencies Act. This gave them the power to essentially create new criminal law by executive order, which is what they did. They created 2 types of measures. They created restrictions on assemblies that could be reasonably likely to breach the peace. And then they created economic measures. So the protest measures, the assembly measures, banned traveling to assemblies that could reasonably lead to a breach of the peace, to be participating in them, or to materially help those assemblies. And then violating those regulations carried a penalty of up to $5,000 and a prison term of up to 5 years. So these are pretty serious penalties.
Very weighty.
Then the financial measures required banks and financial institutions to freeze the accounts of people they had reason to believe belonged to a, quote, designated person. And a designated person was someone engaged either directly or indirectly in those prohibited protests. Those economic measures didn't come with any prior legal authorization, like a warrant. There was no appeal mechanism, and there was no way people could have any prior notice. There was no neutral third party to review whose accounts would be frozen. So we immediately challenged this. We said that the threshold to invoke the Emergencies Act was not met. There's actually internal to the legislation a number of provisions that explain exactly when it can be used for a public order emergency. There needs to be a threat to the security of Canada, and that's defined with reference to another piece of legislation called the Emergencies Act, and it requires the existence of serious violence. And serious violence is a known term in law. It means violence to physical violence to people or property. And there also had to be a national emergency. That means that it was an emergency that could not be dealt with using existing legal tools or authority. We say that those thresholds were not met, and the regulations, those freezing accounts and the assembly restrictions, that those were unconstitutional. They violated the charter right to freedom of expression, assembly, and to be free from an unreasonable search. And at the lower court, Justice Mosley agreed with us that those thresholds had not been met, that the act was invoked illegally, and that the measures were a violation of the right to be free from an unreasonable search and the right to free expression. So that's everything that happened up until the appeal hearing, and then we spent 2 days fighting the government who's trying to have that decision overturned.
Wow, there's so much to take in there. And so you mentioned the the CSIS Act. As I understand it, the CSIS director actually also said that the criteria was not met for invoking the Emergencies Act. And the appeals court heard that again this week. Is that right?
So what the CSIS director said, his name is David Vigneault, he said that there was no threat to the security of Canada. Now remember, the existence of a threat to the security of Canada is what's required to invoke this legislation. He said that none existed. Now, his decision is not determinative, but if the cabinet and the prime minister is going to come to a different conclusion, they need to be relying on something. And the Privy Council office had told the prime minister they would, since CSIS says there's no threat to security of Canada, since the RCMP says legal tools are not exhausted, since the National Security and Intelligence, the NCIA, I forget what the A stands for, but her name's Miss Thompson. She said that there was no threat. If they've all concluded this, and these are the most informed people about intelligence in our country, if they say there's no threat to the security of Canada and you still want to invoke the act, you need to be relying on something. So the Privy Council office said to the prime minister, we'll prepare you an alternative threat assessment, and that was
Hmm.
never done. So for the decision for Trudeau to invoke that act to be a reasonable decision, which is what's required to use this legislation,
Sure.
there needs to be something. You can't just have the entire intelligence community saying no threat and then reach your own conclusion based on no information. That is not a reasonable decision. And that's what happened in this case. There was no other information.
Wow, it sounds like the prime minister really took what was said by these professional bodies, the RCMP, CSIS, and just veered off and totally went his own way in invoking this.
Yeah, that's what we say happened. That if you're going to use this extraordinary law, you need to meet the threshold to use it. And if
Really.
you can't use it on the basis of no information. There needs to be credible and real in evidence that's what the prime minister would be basing his decision on. Now, we think that the Emergencies Act should exist. Like,
Mhm.
this is a law that is very important to be able to address things like wars, real insurrections, terrorist attacks. The government needs to be able to use a piece of legislation like this, but if they're going to use it, they need to have a actual reason to use it. And in this case, they didn't meet that threshold. They had no information they based their decision on.
Wow, it does sound like it. So, Christine, in light of all this, in your professional opinion, did the federal government's lawyers present a sound argument this week for overturning Justice Mosley's decision? What do you think?
Well, look, I have my own perspective. We were in court defending Justice Mosley's decision. So, of course, I think that we did an amazing job defending this decision.
Awesome.
And I think that the decision should be upheld. I think Justice Mosley's decision was reasonable and he met all of the requirements of a judicial review. So, what the Attorney General of Canada said, and by the way, this is not their government lawyer. They actually fired their government lawyer after spending nearly $2.3 million on the losing case at the court below.
Right.
They went out and got a new lawyer, a much more expensive private sector
And
lawyer.
taxpayer funded.
Of course, with taxpayer money. So I'm sure their new bill will be even higher. But their new lawyer said some pretty astonishing things, and
Mhm.
I'll just give you an example.
Sure.
So, as
Yeah.
I mentioned, the standard to invoke the Emergencies Act is a threat to the security of Canada, which requires the existence of serious violence. And that term, serious violence, is a term known in law. It's means physical, real physical violence to people or property. And the federal government has consistently argued throughout this case that economic harm, broad harm to our economy, is the same thing as serious violence. So they have argued that the blockades at the border constitute serious violence because they were harm to our economy. Now, if harming our economy was violence, I mean, I'm pretty sure I can think of a few politicians in this country who are engaged in murder, basically. But it's not. That's not what serious violence is. And he gave an example
Absolutely.
that where he said, you know, if a person were to take a big rig truck and drive it into a booth at the border, a security booth at the border, that would be serious violence. Of course, I agree. That's very dangerous thing to do, and it's the
Of
physical
course.
destruction of property. That would be serious violence. And he
Mhm.
said, but can anyone seriously sit here and say to take the same big rig truck and park it across the road is not exactly the same thing, and maybe even worse? And hi, I would say that it's not the same thing. Destroying a building and blowing it up is not the same thing as blocking a road.
$100%.
It's not the same thing. And it was an absurd analogy that I think undermined the Attorney General of Canada's position, because no one sitting in that courtroom could possibly, I can't imagine that he even agrees with that analogy. That's just not what serious violence is.
Yeah, absolutely. And that's a really a common sense thing that in the courtroom or not, that's easily distinguishable. And it reminds me of the civil cases that are happening from the Ottawa protest time, as well as the Tamara Leach and Chris Barber case, where there were all of these allegations about the horn honking, the noise and the smells, and the rhetoric that could have been offensive. And all of this was also like they were trying to argue that this was violence and that this was detrimental to their well-beings. And so we see a lot of convoluted allegations that are mixing up what is lawful and what is not, what might just be irritating for someone if they don't like their ideology or their perspective.
Look,
And sorry, go ahead.
I want to be clear
Yep.
that I support the right to protest, but it is not, blockading a road is not with something that you can do without facing police consequences. And I believe in the right to
Sure.
protest, and I believe in the rule of law. And I do believe that ending blockades, like border blockades, as well as the blockade out on Wellington Street, was a perfectly legitimate use of police power. The
Sure.
question for us at federal court and at the Federal Court of Appeal was the threshold to invoke the Emergencies Act met, or could this have been resolved with existing police power? Now, let's look at the most serious case from this whole episode, which was the discovery of weapons at Coots, which led to certain criminal charges for some individuals. Not all, I think there was some overcharging in Coots. There were not convictions on everything that was charged. But certainly the discovery of a large cache of weapons and ammunition at that site, it's criminal. So the question, though, is could that have been addressed using existing legal tools and authority, or was the Emergencies Act needed? Well, the entire situation in Coots was discovered using existing police powers, and
Mm.
it was dealt with using existing police powers. And the Premier of Alberta at the time, Jason Kenney, said the situation in Coutts is completely under control, and we have no need for the invocation of emergency measures under the Emergencies Act in Alberta because we have this under control. We don't need the federal government using these tools in our jurisdiction. So that's part of the threshold. The question about whether or not the Emergencies Act can be used requires the federal government to show that existing provincial legal tools or the criminal code or provincial authority had been that authority and that capacity had been exceeded. And it's on its face evident because the most serious situation was resolved with existing tools and authority that threshold wasn't met. The most serious situation was resolved using ordinary police powers.
I see. So it sounds like there's all kinds of other ways that these protests and even the border blockades could have been dealt with short of calling the Emergencies Act. And so that reminds me of something that you said in your synopsis about how Trudeau's lawyers went so far to mischaracterize your organization and those that are supporting Justice Mosley's decision in court this week, where they said that falsely said that your organization said, well, we could just call the army in rather than invoking the Emergencies Act. But you didn't actually say that. And you mentioned in the synopsis that Chief Justice was even bewildered as to where that could have come from. So what does this mischaracterization about your group and just about this situation in general say about this case that the Attorney General is attempting to build on behalf of the Trudeau Liberals?
It says that they're overstating things, and that by mischaracterizing us, what they're doing is building up a straw man so it can be easily taken down because they're unwilling and unable to grapple with the actual legal arguments that we have put forward. It's a lot easier to say that we said something we never did and criticize that than deal with the actual challenging legal arguments that we've put forward. So what happened was the lawyer for the attorney general said that the Canadian Constitution Foundation were sitting here, 2 years later, and they're thinking up all these other things that could have been done or should have been done differently instead of using the Emergencies Act. And shockingly, the civil liberties group said that we could have even called in the army. And yeah, just exactly as you described, the Chief Justice said, "What are you talking about?" And our lawyer jumped up and he said, "We never said that." I do know where that came from, though.
Hmm.
Another civil liberties organization called the Canadian Civil Liberties Association had mentioned in their factum, as part of existing capacity, the federal government could have borrowed towing equipment from the Canadian military because the Canadian military has large heavy duty towing equipment that they say could have been brought in, and that should be considered as a resource under existing capacity, existing legal tools and resources. So they sort of mentioned the military, but they weren't calling for the military to be brought in. That's what the Prime Minister, Justin Trudeau's father, actually did
Right.
during the invocation of the War Measures Act, which is the much more uh, dangerous piece of legislation that the Emergencies Act replaced. And the entire purpose of the Emergencies Act, which is the law we're dealing with now, the whole reason it was enacted was to prevent the type of abuse we saw this prime minister's father engage in the 1970s. So it was created with all of these special thresholds to make sure it was only used in the proper circumstances so it couldn't be abused again. And yet here we are.
Here we are. Yeah, what a pattern. I mean, you can't make this stuff up.
Yeah, I mean, there's that expression that history doesn't repeat itself, but it
Yeah.
rhymes. And, Trudeau rhymes with Trudeau.
I think in this case, you might even be able to say that it does, evidently repeat itself
Yeah.
given everything that you just said. And there certainly is a rhyme, but I don't think anyone is dancing to that kind of tune.
Hmm.
So before we wrap this up, I think that, the most pertinent question here is what are the next steps in this appeal? And maybe even more importantly, is, will any elected officials, including Trudeau himself, including former Finance Minister Chrystia Freeland, will they be held personally accountable? And what happens if Justice Mosley does uphold his decision that this was unlawful? Will there be any consequences?
So the consequence would be that this creates a binding precedent that will prevent future governments from doing this type of abusive thing again in the future. This is first time it was the first time the law was ever used. So this is the first time the law's ever been interpreted by a court. So that will dictate how the government, or should dictate how the government, uses it or doesn't use it in the future. For personal accountability, the recourse we have for that is in the voting booth. So if people are unhappy with what the prime minister did in this case, they can vote for a different prime minister. There is some possibility of civil recourse for people who had their bank accounts frozen and were hurt by this, because of course, if your bank account's frozen, you may be unable to pay your bills, you may have your credit rating impacted. This could cause harm to people, and so I know there are lawsuits underway on those issues. We're not involved in those. In terms of next steps, the decision is at the Federal Court of Appeal. We typically expect a case to take about 6 months for a decision, but there's never any promise on that. This case might take a little bit longer because it's an especially complicated case. I think Justice Mosley might have taken 8 to 10 months for his decision, and this case, as a federal court decision, I believe will need to be translated into French before it can be released. An interesting question is about an appeal of whatever this decision is. Now, if
Okay.
if there is whatever happens, I mean, we're going to get a result. If we at the Canadian Constitution Foundation are successful and the court upholds the ruling that the use of this law was illegal and unconstitutional, if there is a new government in power, like a conservative government, the conservative government has been very consistent in their view that this Trudeau should not have done this. So we don't know what a conservative government might do, but if we're successful, they may not appeal the case because I think that they agree with us. So if there's a new government and we win, it may never get to the Supreme Court. If we lose, then of course we would appeal, and that would go to the Supreme Court. But a lot of things could happen in the next in the next 6 months. So
A lot of
right
unknowable.
now, yeah, we're just waiting to see what the outcome will be, and we think it went really well. We're very optimistic.
Awesome. It sure does sound like it. I've certainly been following along. I've actually been tuned in through the Zoom link myself, watching what's been going on in court. And I totally agree with you with much what you were saying about the Trudeau's lawyers, the Attorney General, kind of clutching at straws, trying to build a straw man argument, as you say, just to tear it down. So we'll certainly be following this as we wait for Justice Mosley's decision on the appeal. And thanks so much for joining us today, Christine, and for your work representing Canadians through the Canadian Constitution Foundation as well. So thank you
Thank you.
and take care. Thank you.
Thanks.